Welcome to Breaking Ties, Destination Divorce. This is your go-to source for practical advice and support while you go through the divorce process. Join us each weekday for a quick chat where we'll cover a variety of topics such as child custody, property division, and self-care. Together, we'll explore emotional, financial, and legal aspects of divorce and help you find the best path forward for you and your family. Here's your host and Certified Divorce Financial Analyst professional, Mike Fulkerson.
Hi, and welcome back to Breaking Ties, Destination Divorce. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional. So, in today's episode, we're going to really dive into an important aspect of divorce that it directly impacts the well-being of children involved, and that is child support. So if you're navigating the divorce process and have questions about child support, then really you're in the right place today. So we're going to hit this up. And we're going to explore what you need to know about child support during this challenging stage of your life. First, it's really critical to understand what child support encompasses. Child support really is a court-ordered financial contribution from one parent to the other to cover costs associated with raising the kids. These costs can include, but really they're not even limited to, food, clothing, education, medical expenses, and extracurricular activities. Child support is often determined by some guidelines set up within your state. Most jurisdictions have these guidelines and formulas in place already, and they really are just the crutch and basis of how you get to a number. And they're going to take some factors into consideration, such as each parent's income, the number of children, and the specific expenses related to the children's needs. So understanding the guidelines is really quite important since it does vary state to state. Now, the non-custodial parent typically pays the child support. In most cases, the parent whom the child doesn't stay with 100% or 50-50 or whatever is, paying the child support. And the amount is really determined based on the guidelines and specific circumstances of the parents and how the states view, time spent with the kids. So while guidelines provide a standard calculation, there may be circumstances that justify deviation from the prescribed amount. Factors such as special needs, medical expenses, or shared physical custody can influence the court's decision to deviate from the guidelines. And child support orders are not necessarily always set in stone. They can also be modified. So if one spouse has a significant change in circumstance, maybe a change in income or the child's needs, then either parent can request a modification of child support. It's important to stay informed about your rights and responsibilities regarding potential modifications. Now, open communication between co-parents is really critical when it comes to child support. Discussing and agreeing on financial responsibilities, will help maintain supportive co-parenting relationship, and more importantly, that ensure that the child's needs are met. So, what if the non-custodial parent fails to pay? Well, there are enforcement mechanisms that can be used, and they include wage garnishment, property liens, and other legal measures to compel compliance with the child support order. So, as I'd said before, state laws do vary. So, understanding the child support laws in your state is probably a wise decision on your part. Consulting with a family law attorney who specializes in divorce cases can provide valuable insights into the legal framework applicable to your divorce case. Now, interestingly enough, child support really is about the child's well-being. And so it's not about the financial relationship between parents, but really what's best for your kids. And both parents share the responsibility of providing financial support, so that the child's needs are met. In conclusion today, navigating child support during the divorce process requires really, a clear understanding of guidelines, communication between the co-parents, and you got to adhere to the legal obligations. Prioritizing the child's well-being and staying informed about your rights and responsibilities are key aspects of this journey. I'd like to thank you for joining me on this episode of Breaking Ties Destination Divorce. Should you have any questions on this topic or other financial planning issues that I can assist with, my contact information is in the description. Don't hesitate to reach out. Divorce is not the end of your story. It is the start of your next great chapter. And with that, have yourself a good day. Hi, and welcome back to Breaking Ties Destination Divorce. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional. Today, we're going to get into a topic that, it's really one of the most important pieces of the divorce proceedings, and that is the financial affidavit. If you're in the midst of a divorce or considering one, understanding how the financial affidavit works is pretty critical. So we're going to unravel the complexities of this document and the significance of it during the divorce process. Now, let's start with just the basics. What is a financial affidavit? Really, it is a sworn statement that details each spouse's financial situation. Simple enough, right? Well, it includes information about income, expenses, assets, and liabilities. And really, this document is a key tool used by the court to determine issues such as spousal maintenance, child support, and property division. So, accuracy is actually pretty critical. I mean, the financial affidavit is a legal document, and providing accurate information is required. Courts heavily rely on the details presented in this form to make informed decisions. Misrepresentations or omissions of financial information can have serious legal consequences in the end. Information included in the financial affidavit, really includes details about each spouse's income, including wages, bonuses, and investment income. It also outlines monthly expenses, such as real estate and vehicles, as well as debts and liabilities. Supporting documentation is sometimes required to justify what's written down on the financial affidavit. So this can include things like pay stubs, tax returns, bank statements, and other financial records. Providing thorough documentation really does enhance the credibility of the information presented. The financial affidavit guides key decisions throughout this process. I mean, courts use the financial affidavit to make important decisions. For example, it can be used for determining spousal maintenance. The court assesses each spouse's financial situation and then will establish a fair and reasonable amount. Child support calculations are influenced by the financial affidavit. The information provided in the financial affidavit really does play a critical role in figuring out how much child support is going to be needed. And they consider each parent's income, expenses, and other financial factors to determine the appropriate amount of support. When we get into property division, it's listed on the financial affidavit, and, we've got to divide that marital property. So the court takes into account the financial situation of each spouse as outlined in the financial affidavit. This helps ensure an equitable distribution on the overall financial picture. And then you move into sort of the settlement agreement with, and negotiating it. And it's the central document during any negotiation and settlements, really, when you look at everything. Both parties, along with their attorneys, will use the information provided to reach agreements on various aspects of the divorce, from spousal maintenance to the division of assets. Now, amendments can be made if circumstances change during the divorce process. Now, even afterwards, too, either party may request amendments to the financial affidavit. This could impact ongoing obligations such as spousal maintenance or child support if something happens to one of the spouses. So, given the legal and financial implications of the financial affidavit, seeking, professional guidance is advisable. You want to consult with a family law attorney who specializes in divorce. A financial advisor could also help that get the information and make sure that it's presented in an accurate, complete, and aligned with your best interest. So as we wrap up, the financial affidavit really is a critical document that shapes key decisions during the divorce process. So we want to provide accurate information, and we want to understand the implications of this document so that we get a fair and equitable resolution to the divorce. Thank you for joining me on this episode of Breaking Ties Destination Divorce. Should you have any questions on today's topic, or you just have financial planning questions in general, just give me a shout. My information's in the description. Email, call, perfectly fine. Divorce is not the end of your story. It is the start of your next great chapter. And with that, have a good day. Hi, and welcome back to Breaking Ties Destination Divorce. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional. Now, today's topic is going to explore a fundamental question that often arises when going through the divorce process. Are all divorce laws the same in every state? And do we even need to know them during the divorce process? Let's dive into the intricacies of divorce laws and their implications on your journey to separation. Now, we're going to start with the importance of understanding that divorce laws can vary significantly from state to state. That's right. No two states are alike. Each jurisdiction has its own set of rules and regulations governing divorce proceedings. Factors such as property division, spousal maintenance, child support, child custody are all subject to specific state laws. Now, understanding your state's residency requirements is also important. In many cases, you must meet specific residency requirements to file for divorce in a particular state just to get things going. These requirements can range from a few months to a year of continuous residence. Ensuring you meet these criteria is essential before initiating the divorce process. Now, property division laws can also differ. One of the key aspects affected by state laws is really the division of marital property. Some states follow community property laws where marital assets are split equally, while others adhere to equitable distribution, where the division is based on fairness but not necessarily equal shares. Spousal maintenance laws also vary. Spousal support, alimony, spousal maintenance, they all go by different names, but it's another area where state laws really do come into play. The eligibility, amount, and duration of spousal maintenance can differ significantly from state to state. Understanding the specific laws in your jurisdiction is important for both the paying and receiving spouse. It's no surprise that child custody laws are state specific as well. I mean, everything else has been, right? So if children are involved, custody arrangements are determined based on those state laws in which you live. Factors such as the best interest of the child, parental fitness, and the child's preferences may influence custody decisions. And these criteria can vary between states widely. Even child support calculations differ. State guidelines dictate the calculation of child support payments. The income shares model or percentage of income model may be used, but the specific formula and considerations can vary. You're going to want to familiarize yourself with your state's guidelines so that you can plan for that accordingly. And then, really the legal process itself varies state to state. So the legal procedures and paperwork required for divorce can differ from states. From filing the initial petition even to attending court hearings, understanding the specific procedural requirements in your jurisdiction ensures a smoother navigation of the divorce process. Now, consulting with a local attorney is actually advisable. Given the state-specific nature of divorce laws, consulting with an attorney familiar with the laws in your area is highly recommended. I mean, a local attorney can provide tailored advice, ensuring that you navigate the legal landscape with precision. Wrapping up here today, the variability of divorce laws across states underscores the importance of understanding the legal aspect. And as you embark on your journey to divorce, being informed about state laws empowers you to make decisions aligned with the legal framework applicable to your case. I'd like to thank you for joining me on this episode of Breaking Ties, Destination Divorce. Should you have any questions on today's topic or other financial planning questions, my contact information is in the description. Please feel free to reach out. Divorce is not the end of your story. It is the start of your next great chapter. Have a good day. Hello and welcome back to Breaking Ties, Destination Divorce. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional. And today we're going to look into a topic that adds an extra layer of complexity to the divorce landscape: common law marriage and getting a divorce. If you've ever wondered how common law marriages work and what the divorce process entails, well, you're in the right place today. Let's unravel the intricacies of this topic. Firstly, it's crucial to understand what common law marriage is to start with. Common law marriage is a legal framework that recognizes a marriage without the couple having obtained a marriage license or participated in a formal ceremony. Instead, the marriage is established through the couple's mutual agreement to be married and their conduct indicating a marital relationship. Common law marriage varies by state. Not even all states recognize common law marriages, and the criteria for establishing such marriage can differ. Some states explicitly recognize common law marriages, while others, frankly, just do not. Understanding your state's stance is essential when navigating the complexities of common law unions. Establishing a common law marriage requires specific elements. While the requirements vary, common elements include mutual agreement to be married, living together as a married couple, and presenting themselves to others as a married couple. Meeting this criteria is critical for a common law marriage to be legally recognized. Now, common law marriages may have some of the same legal status as formal marriages. In states that recognize common law marriages, these unions generally have the same legal standing as marriages established through a formal ceremony and marriage license. This includes rights and responsibilities related to property, spousal support, and divorce. Divorce in common law marriages follows a similar legal process. When a common law marriage faces dissolution, the divorce process typically mirrors that of a traditional marriage. Issues such as property division, spousal maintenance, child custody, and child support are addressed through legal procedures. Property division considerations are similar. In common law divorces, the same principles of property division apply. Marital property acquired during the common law marriage is subject to equitable distribution or community property laws, depending on your state's legal framework. Spousal maintenance considerations are also relevant. Alimony or spousal maintenance may be a consideration in common law divorces. Factors such as the length of the marriage, financial disparities between spouses, and each spouse's contributions to the marriage are taken into account. Child custody and support follow standard procedures. Common law divorces involving children follow the same procedures as traditional divorces. The court determines child custody arrangements based on the best interest of the child, and child support is calculated according to state guidelines. If you want to know more, look up your state procedures, and it will actually tell you how things work. Legal representation is still advisable, given it is a legal process and the complexities involved in common law divorces. Seeking legal representation is really highly recommended. An attorney familiar with the specific laws in your state can provide guidance and ensure that your rights and interests are protected. So in conclusion, common law marriage and divorce adds a layer of complexity to the already intricate process of marital dissolution. Understanding your state's stance on common law marriage and seeking legal advice when necessary can help you navigate the divorce process with clarity and confidence. I want to thank you for joining me on this episode of Breaking Ties, Destination Divorce. Should you have any questions on this topic or other financial planning issues, feel free to reach out to me and contact me. Divorce is not the end of your story. It is the start of your next great chapter. And with that, have a great day. Hi, and welcome back to Breaking Ties Destination Divorce. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional. And we're going to get into a topic today that many may not consider at first, but holds a significant emotional weight. And that would be, how is the family pet handled during divorce? If you've ever wondered what the family pet is whether the part is the divorce process, you're really not alone. We're going to explore the complexity surrounding this often overlooked aspect of marital dissolution. And it's important to recognize that pets technically are considered property under the law. While we often see our pets as beloved members of the family, the legal system views them as personal property. And this classification can influence how decisions about the family pet are approached during divorce proceedings. Custody arrangements for pets are not the same as custody arrangements for children, So unlike child custody, which considers the best interest of the child, custody arrangements for pets focuses on ownership. The court may determine who has legal ownership of the pet and therefore the right to make decisions about its care. The courts will consider various factors when determining pet custody, such as who primarily cared for the pet, provided financial support for the veterinary care, and has the emotional and physical ability to care for the pet post-divorce. You can negotiate pet custody outside of the court. That's definitely an option. If both parties are amicable, then negotiating custody arrangements outside of the court could be a viable solution. And this might involve creating a shared custody arrangement or agreeing to primary custodian with visitation rights for the other party. Prenuptial or postnuptial agreements can address pet custody, including provisions for pet custody in a prenuptial or postnuptial agreement can provide clarity and avoid potential disputes in the event of a divorce. Such agreements can really specify ownership and care arrangements for the family pet. Now, regardless of the legal considerations, it's actually important to prioritize the well-being of the pet. Stress of a divorce can impact animals as much as it can people. And maintaining a stable and caring environment is essential for their health and happiness as well. So you really want to think about, your pet as you go through this process. If disputes over pet custody arise, then mediation can be a helpful alternative to court litigation. A third party that's neutral can assist in really facilitating discussions and reaching an agreement that's fair and considerate of both parties' attachment to the pet. While some pet owners may want visitation arrangements similar to child custody, it's also important to note that courts may not enforce visitation agreements for pets. Once ownership is determined, the legal owner has the final say in the pet's living arrangements when it's all said and done. Now, wrapping up today's episode, the fate of the family pet during divorce is really a nuanced matter that requires careful consideration. While legal frameworks view pets as property, the emotional bonds we share with our furry friends add layers of complexity. Whether through negotiation, mediation, or legal proceedings, finding a solution that prioritizes the well-being of the pet, it really is the first and foremost thing you should do. I want to thank you for joining me on this episode of Breaking Ties Destination Divorce. Should you have any questions on today's topic or other financial planning issues I can assist with, my contact information is in the description. Feel free to call, email. I'll do what I can to give you a hand. Divorce is not the end of your story. It is the start of your next great chapter. Have a great day.
I want to thank you for listening to this episode of Breaking Ties, Destination Divorce with Mike Fulkerson. For questions, please reach out to Mike via email in the description or give him a shout at 630-444-1410. Remember to subscribe, like, and follow.